So we will get things going. This meeting was tabled from our last gathering of Monday, June 3rd, I believe was the date. So we will just pick up where we left off. First off, note that we have 4 board members here, so we do have a quorum. At the time of that the meeting was tabled, I believe we were deliberating. We had closed the meeting to outside comment, and the Board of Appeals was deliberating the facts at hand. We had asked, and Jordan, will your counsel be here tonight?
This is my other counsel.
Okay, all right.
We've been kind of going back and forth here. They've both been involved.
Wonderful. Ms. Cohen, I presume? Yes. Hi. Okay, no? Great, great. So, I want to make sure that I do this properly. I'm new to the chairmanship, but, so we'll pick up where we left off, which, Cliff had said that he would appreciate hearing from council on some of your, some of the backing that you have for your appeal. That being the case, Ms. Cohen, if you want to pick up where we left off, we will continue with this hearing. We have,
So I don't want to be repetitive. I know there were some specific questions that were asked, and Attorney Ketchum sent out some additional information going way back to 2009, when the caregiver program started to really take shape and was way less defined than it is today. So you were provided with a definition from LD 75 in 2009 of quote usable marijuana, which included, among other things, any mixture or preparation of those dried leaves and flour. So even back in 2009 and 2010, the caregiver program contemplated compounding or mixing or preparing cannabis, that it wasn't just going to be in its flower form. There were additional sort of nods to it. LD 975, which was from 2000, also 2009, had a section 2, specifically about drug paraphernalia, and for the medical program, it excluded a long list of things. And if you sort of extrapolate and look at that long list of things, it excluded the means for preparation and compounding of marijuana. So it was even contemplated to be excluded from a definition of drug paraphernalia. Because it was acknowledged that it would be used by caregivers. We then had, again, the caregiver authorizations, a list of them added via LD 1811, 2010, which was retroactive to December 23rd, 2009. And that was the first time you saw a sort of a long list of caregiver authorizations. And one of those things was, again, that definition of usable marijuana that included any mixture or preparation of dried leaves and flowers. And you really see the program start to take shape in 2018 with LD 1539 and then really LD 1129. And I know I'm throwing all these numbers out at you. And then the biggie, LD 238, which was when the Office of Cannabis Policy received their mandate to license IHS labs, inherently hazardous substance extraction labs, which is what is at issue here today. But part of LD 1129 that now is in code section 2429D is the state grandfathering date that you probably heard referred to on June 3rd. And we've certainly raised this issue with the select board, and it's in the letters if you've reviewed the letters that I've submitted. But 2429D is a provision that talks about the state grandfathering date. So any business that was in operation with local authorization as of December 13th, 2018 is grandfathered under state law. And so that is really the issue here. The threshold issue is whether or not Jordan and his business are grandfathered under state law. Our position all along is that he is. He's been in operation here since 2011. He has had touch points with the town throughout that time where the town was aware. I mean, lives right down the road. He's a home-based caregiver. So he's not far from town hall. The town's been out. We have a letter in 2022 from the then code enforcement officer that refers to Jordan as a grandfathered caregiver. So up until this year, when the Office of Cannabis Policy finally fulfilled their mandate to license these businesses, there really wasn't an issue. But then they generate this form called a local authorization form, and it requires Jordan to come to the town, to the code enforcement officer in this case, and have the town sign off on this form. And the form itself, if you look at it, I hope you have it. I've provided it in the past. And I'm without internet at the moment, so I can't look it up. But there's a section on it. Thank you so much. So there's a section on it that operates to sort of inform the towns what this form is, and it encourages you to reach out to the Office of Cannabis Policy if you've never had to fill out the form before. I don't think that happened in this case. That's not a criticism, just a fact. And what it requires is that either the town have an ordinance or a warrant article specifically on point allowing these activities, or that the applicant is grandfathered. So this town is not required to have an ordinance or a warrant article. All this town is required to do is acknowledge that Jordan is grandfathered under state law because he's been operating here since 2011. And so what happened here was when this form went to the code enforcement officer, her response was specifically to say, there's no current ordinance, there's no future ordinance, I'm not going to sign the form. And so that's what she relied on, which was in error. Because this town is not required to have an ordinance if the town finds that Jordan is a grandfathered caregiver. So there was never an examination of whether he was grandfathered. So the decision made by the code enforcement officer is in error. It is how we ended up at the Zoning Board of Appeals based on that error. And so we're asking that the town acknowledge that Jordan, just like the 2022 letter says, that Jordan's a grandfathered caregiver for all of his authorized caregiver activities, because he's been operating in this town for more than a decade. The letter that was provided to him by this town has been relied upon 2 years in a row by the state as local authorization. It was never rescinded or disputed by the town. So the error occurred when the code enforcement officer was trying to rely on an ordinance and there wasn't one. The correct outcome, we believe, would be the town acknowledging that Jordan's grandfathered. So this is all I do all day long, so I could talk about this as much as you want. I'm happy to answer questions. I know you've got an attorney here to advise you as well.
Attorney
Thank you.
Cohen, I have a couple of questions for you. First of all, the letter that you referred to said that he's been in operation since 2011 and is grandfathered, whatever Mr. Hill meant by that, for cultivation of marijuana. Didn't say anything about IHS, didn't say anything about extraction of any kind, just said for cultivation.
It was specifically worded that way, but then went on and listed additional activities, including.
Well, it went on and certified that he had looked
Manufacturing.
at the equipment and that it looked like it complied with, that an engineer had certified it, which is something that Jordan has to prove to the state's satisfaction. But the real question, isn't the real question under the statute whether the town had granted municipal approval for the IHS extraction activity prior to December 13th of 2018? Isn't that the thing that the CEO would have to certify on this form?
What is required, and I think it shows up on the local authorization form, is some evidence of municipal approval of Jordan's activities.
Well,
So, and it lists examples of it, but I don't believe that's an exhaustive list.
well,
But
it lists as examples
electrical permits.
Well, it says that those wouldn't count as municipal approval. It lists a couple of things that would count: conditional use approval, special exception. It's undisputed, those things don't exist here, correct? Okay. And then in addition to those illustrations, it actually gives its definition of what municipal approval means. And it means that there's been an examination of the premises and an approval of those premises for the use for which the applicant is seeking permission under the Medical Cannabis Act, right?
Correct.
Okay. And there's never been an examination prior to December 13th of 2018. There's never been an examination by the town of the premises for approval of IHS extraction, correct?
That I'm not sure. I believe the town has.
Well, the town's given me approval multiple times over the years.
Well,
It's, you know, it's really, there's an issue here with record keeping with the town because we went through 8 years
Who-
of minutes.
prior to
and the
December-
name didn't appear.
prior,
Those in regards to like the affidavits we submitted last.
prior to December 13th of 2018,
Mhm.
who for the town examined,
board.
let me finish the question
One second.
before you answer. Prior to December 13th of 2018, who for the town examined your premises for purposes of approving it for IHS extraction?
Ryan Keith.
Ryan Keith, the CEO?
Yep.
Okay. And when did that happen?
In 2018,
When in 2018?
the summer of 2018, August, I believe,
When did you begin using butane to extract?
2011.
And when did you seek registration from the state to approve
When we
IHS
were
extraction?
legally required to do that by the state.
When?
So the form that I was just referring to, and this specific process started in January of 2024. Prior to this year, the Office of Cannabis Policy had not put out a license application or a process. All we were required to do was submit a letter that stated, you know, this is the caregiver card number, this is the address, these are the names of the employees and their dates of birth, and we are engaging in inherently hazardous substance extraction. And you had to select a tier 1 or tier 2 based on how much biomass you would have. And that was the process.
When that statute came into effect, didn't it require that an applicant for permission to engage in IHS extraction?
No,
What? You gotta let me finish my questions before you try to answer them, okay? Didn't it require that an applicant for registration show that prior to engaging in the activity, they had given notice of intent to engage in IHS extraction? Doesn't the statute just
not
say
at
that?
time. But it was not, if the statute says that, and again, I'm in a slight disadvantage because my internet, I'm not able to connect. If the statute says that, it was not part of the process. And I've been doing cannabis law in Maine since 2016 when I became licensed here. So I remember when this went into effect. And I remember submitting what we would call an LD 238 letter.
Mhm.
And there was never any follow-up to it. And all we were required to do was make sure we had notified the state of the address and the name and dates of birth of those who were employed there and under whose caregiver card and whether it was a tier 1 or tier 2.
What was the purpose? Did Mr. Keith just come out to your property or
So-
did you ask him to come out?
Yeah, I asked him to come out.
Okay, why would you ask him to come out when you didn't need any local approval?
Because we knew that there was gonna be were going to be changes in the future. So we were starting to get, set up to upgrade, basically like different safety, equipment and stuff that we had.
Okay, and in what form, is there any writing that reflects that approval from Mr. Keith?
You'd have to ask him.
I'm asking you, do you have any?
I do not. Again, I think, you know, there's some discrepancy in the record keeping locally here. You know, case in point, there was no record of this letter from Allen Hill on file anywhere. So I don't know if it should be expected of me. I understand I should have something like that. And the other thing I'd like to mention is since 2010, when we moved here, I've asked for home occupation license. I've asked for things in writing to acknowledge, and I keep being told that it's under the purview of the state program, yet I'm told explicitly that we're able to operate within your town. And, I'm really at a loss here as to why I guess we just can't figure something out. And all procedural things aside, and I'll say that Jill here has worked with over 10 different towns
At
to
least.
work out situations like
What
these
he's
where,
referring to is sometimes, so one of, and you've heard him voice it, one of our concerns is how many touch points he has had with the town. It's not like he's hiding out doing IHS in a tent in his backyard. And believe me, that used to go on all over the state of Maine before we had a more robust regulatory framework. He's literally down the street. And he's had all these touch points with the town. He's requested documentation. It just wasn't part of your process, and that's fine. But the only thing that's changed now is the process at the state level. And he's gone through it for the last 2 years using that very letter and been approved for all of his activities using that letter. So I know that that letter is the subject of controversy because I've been here at all of the meetings except one, but it really isn't, because like I've pointed out, nobody took any steps to put Jordan on notice that he couldn't rely on that letter. So much so that he relied on it 2 years in a row to get his caregiver card renewed. And so I think one of the questions that really resonates with him that he struggles with is why now? You know, why are you coming down on him now? All we're asking you to do is acknowledge that he's grandfathered. He has been operating in this town for more than a decade. He's a resident here. He raises his family here. And initially, you know, I mean, that is the threshold question, I think, for the ZBA, is whether or not he's grandfathered. And I think there's enough evidence to show that he is.
Is butane a hazardous material under our hazardous material controls ordinance?
Yes. That's why it's IHS extraction.
yeah, we fall all.
No, but I mean, under Pownell's hazardous
Oh,
material
I'm sorry,
control.
that I don't know. I'm sorry. I don't know.
There's no disposal of anything.
It's a
Right, but
close-
the ordinance
But it would be
governs the
like-
use of hazardous
Right,
materials as
but I have a
well.
propane tank in my yard that's 500 pounds, which has far more flammable solvent in it than the lab does.
Well, I mean, I
Well,
think
but
that's-
the ordinance allows people to use fuel,
Okay,
but using butane as a solvent for extraction of THC or whatever you're extracting from.
does it prohibit that? Does it prohibit that?
Well, it prohibits the use of hazardous materials. So I'm just trying to work through my mind.
His
Do you have
equipment's
a
been
copy of that?
certified as,
What's that?
you know, his equipment's been certified.
I'll bring it up now.
And also
I understand that.
about
But
the
we're
process.
not talking about whether his process meets state standards. We're not talking about any of that. We're talking about, was there actually a request and a granting of municipal approval of IHS extraction prior to December 13th of 2018? And we don't have any written evidence of it having happened. We have a question, at least in my mind, whether it even could have been permitted because of the hazardous materials control ordinance. There's a question in my mind whether it could have been permitted because as even a permissible use under the zoning ordinance, because it's not I mean, a home occupation is permitted in that zone, but manufacturing is not, right?
You know, home-based caregivers enjoy certain protections at the state level that wouldn't ordinarily apply.
Oh, and I totally understand. I
it's
totally
sort of-
understand your position is the town had no power
Not that you had
To-
no power.
to.
I would
to-
never say that.
The town had no power to prohibit him.
Up
right?
until a certain point,
Right.
Correct, up to a certain
but then
point.
chose not to.
And part of what's gone on at the state level really should provide reassurance to the town. They finally do have this process in place. They've had a mandate to do it for 6 years and are just now getting it done. And the sky didn't fall during those 6 years. But also part of that process is he has to provide documentation to the state of all the testing of his equipment. And that's never been part of the process before. So they're tightening all the things up. It's arguably never been safer.
Right,
or
but
regulated.
But the question before us right now is not whether we should be approving of this activity or not. The question is, can we certify what this form is requiring us to certify? Which is that prior to December 13th of 2018, there was an examination by the town of the premises and an approval given by the town to those premises for use for IHS extraction. And I'm not seeing any written evidence, certainly, that that's the case. And it would be surprising to me that that would have happened without written evidence, given that there were a number of potential ordinance obstacles to that.
I think it's a true factual dispute, and I'm not sure how to resolve that, which is why our initial approach, because we knew there was going to be a true factual dispute. I have no reason to doubt Jordan. Has a very specific recollection of this inspection, and he's been fully transparent with the town throughout this entire process, with this body and with the select board and with everybody else. So I don't know how you resolve a factual dispute, and that's why from the beginning, we've hoped to reach a consent agreement with the town, because that's what you do when, you know, you've got this conflict and you feel like it could go either way, and maybe you don't feel like it could go either way. I think it could. I think Jordan's testimony is evidence, and the things he says have to be taken at face value, and you'll judge his credibility. And like you said, you know, just from a procedural standpoint, you I can't remember your exact words, but would find it hard to believe there wouldn't be a written documentation of it. But here you have a town resident, you know, you'll judge, but he hardly strikes me as somebody who'll do anything to win. I mean, he's poured out his heart every week he's been here. And he's telling you that he had an inspection and that the town, every time he asked for something in writing, gave him reassurances. Oh, it's fine. You're controlled by the state. You're regulated by the state. That was the answer he got time and time again.
Yep.
And I'm not calling into question the genuineness of Mr. Smith's belief about
Sure.
what,
You understand the situation.
what he
has been
recalls.
Put in by the town.
the question is his recollection or is his belief about what happened correct? Is it what really happened? And that's the piece that's harder to wrap our head around. Let me ask you a different question. At the last meeting, a question was raised about our jurisdiction. And I guess I'd like you to speak to that, and I can tell you sort of what is on my mind, and you can maybe guide me through that.
I mean, you have a little more authorization than you used to. You know, towns can't prohibit or limit the number of caregivers, particularly protected or those operating at home.
I mean, the jurisdiction of the zoning board of.
Well, the zoning board of appeals, well, I know, we talked about this on the way in. I think, you know, I think your attorney will advise you, but my understanding is that the job of the zoning board of appeals is to address a potential error and to decide whether or not an error has been made. And outside of that, you know, things like when I refer to, we would love to reach a consent with the town. I don't know that that falls within your authority. I think that would send us right back to the select board. But we would hope if that's where we're headed, it would be with a message, hey, you know, there's enough smoke clouding the room that we need to work this out with Jordan. Because I do think he has been earnest in his attempts to stay on the town's radar. And, you know, we're just never really going to be able to resolve that factual dispute. Because the issue he raises about record keeping is a real one. As evidenced by everybody's reaction to that letter that people didn't know exist and didn't exist in any file in the town office. That's not great. And so, you know, what we hope you find tonight is that he's a grandfathered caregiver and that this is done and that the code enforcement officer signs the form and we go on our way and he'll be back next year to get the form signed again, because that is what we think is the right outcome. He has been operational here in his current configuration since 2010. But if the Board of Appeals does not find that, you know, we hope that you'll send a message back with your finding that you think there are some issues here. And that maybe the select board would look at entertaining a consent agreement that doesn't put him out of business and that continues to put all of those safeguards
Which
in
I'll
place.
be in 10 days from now.
And you keep saying that we'll find that he's grandfathered. We're not going to make a decision under state law about what his status is, right? So,
Well,
so the real question, is, can we certify what the state needs certified in order? Let me back up. I understand you have a construction of these statutes that says before the 2017 or 2018 amendment, the implicitly, though not explicitly, the definition of usable marijuana and then harvested marijuana implicitly included extraction. Correct?
May I speak to that?
It included mixture or preparation, and those two words are subject to interpretation.
And that by implication, your interpretation is that means that extraction activities
Correct.
fell within permitted activities.
Correct.
Right? And that's what Mr. Ketchum referred to as the great grandfathering, right?
Sure.
Okay. And that's not something that we can decide. Because that's for,
It's a component.
Oh, so
that's
I
for
don't
the
think
state,
you-
that's for the state to
I
decide,
don't think you
right?
can decide great grandfathering, but the grandfathering, I do think is a straightforward.
Right. So the thing that
determination.
we can decide is, did the town examine his premises prior to December 13th, 2018 and approve his premises prior to that date for IHS extraction? That's the only thing that we can answer sort of factually yes or no, assuming we have jurisdiction. So let me back up to the jurisdiction question and tell you more specifically where my question is coming from. The jurisdiction of the Board of Appeals is defined as reviewing action or failure to act by the CEO in the enforcement of the ordinance. That's the literal words of the jurisdictional provisions. In my mind, it's unclear to me whether that means that we are confined to reviewing actions or inactions that the CEO takes in enforcing the ordinance. No enforcement has been engaged in here. Or does it include sort of the ability to review the CEO's interpretation of the ordinance in any way that aggrieves a person?
I have a question.
Yeah.
In light of your explanation. So we're in a situation where you don't have an ordinance and
Well, we have a zoning ordinance.
you don't have anything that speaks to caregivers.
Correct.
So I understand you have a zoning ordinance, but if we start from the premise that towns can't limit or prohibit home-based caregivers, your zoning ordinance wouldn't apply.
Correct. And there'd be no enforcement activity for us
Right.
to review as a Board of Appeals. We'd have no jurisdiction.
So I guess now my question in response is where state law controls, where does the zoning board of appeals fit? That's why I said the only body that can make a decision about whether or not the town considers him grandfathered would be the town. And that may be based on state law and the things that you've cited about what that grandfathering means, whether or not the town has had a meaningful review, whatever the exact language is that you read to us. And so that's, in my mind, that's the decision being made by the ZBA. And you've been presented with evidence through Jordan's testimony, through some other gaps in record keeping that we've pointed out that would explain your concern, that it would surprise you that there wouldn't be anything in writing. He's not surprised by that at all. And that his testimony, that letter not being where it should have been, you know, all of the other things that have been said, that's actual evidence to be considered by the zoning board of appeals when you decide, was there a meaningful review? Did the town know he was there and view his property and allow him to continue? He's never received a notice of violation or any other sanction from the town. And it's tough.
That's something the town would not have had the power to do,
They could
correct?
have asked him to get a home occupation permit and he
Yeah.
repeatedly asked
Or
about that.
you-
They couldn't deny that permit, but they could put him through the process to sort of get him on the town's radar, give him some performance standards. I mean, you can do that. Your home occupation performance standards, had he been required to get a license, and those are things like, you know, the number of car traffic and the number of employees, you would have been able to enforce that on him, even though you couldn't have denied the permit. So the town has had other opportunities to regulate him and chose not to. And always would say to him, you're governed by state law. That would be the answer he got. So he's in this catch-22 where, you know, the town could have, you did have mechanisms in place to license him. And no one thought that that applied to him because they thought, well, he's governed under state law. And that's our argument today. He's grandfathered under
That
state law.
can't constitute municipal approval under the statute.
Well, no, it's not that alone. He's saying that when the code enforcement officer came out and reviewed the property, that was a town review. That's a town representative that he granted, asked him to come over because he's CYA, right? He knows because Jordan's involved in the legislature, like he told you, he knew what was coming from a regulatory perspective for
I helped write
IHS.
LD
He helped write
238.
LD two thirty-eight.
Why not get it in writing at that time?
I
You
he
guys wouldn't
repeatedly
give
asked
me
for it.
anything in writing for 14 years.
He did. He, that's what, how
I've
he
asked
describes
every
his
year,
relationship
like,
with the town.
But you asked Ryan to come out specifically, you say, to comply with this coming statute.
Yep.
And why not get it in writing from
Well,
him at
he
that
issued
time?
the electrical permit and the plan, and then the plans were.
Yeah,
for
but the statute is clear that an electrical permit, a building permit doesn't count.
Right, but also he inspected the site itself, like we needed it was a power upgrade. It wasn't like we've been operational.
But if your whole purpose of having him come out to the site was to have him review and approve it for purposes of the statute that you knew was coming down the pike, why would you not have,
When
why would you not have asked him to put that in writing?
he was on his way out, he didn't want to make, there's a lot of stuff going on in this town where he had, I'll be honest, he just approved the wine tasting place up the road. And he got a lot of flack from that, and he lost his job because of that, is my understanding. And he didn't feel super comfortable communicating to the town some of the stuff he was doing, I think, at the end of his tenure. And I'm a victim of that too. That's not my that's not my fault that all of these years I've asked for all this documentation and it's been refused to me. And may I remind you, I met every single qualification to receive a home occupation license. And I offered up my caregiver confidentiality in order to receive that, to have record of myself operating as a business in this town, so that when days like this come, I can look back and say, here's the thing that you gave me that I asked for, that you were legally obligated to give me. But I never received any of those things, and that in itself may be its own big problem.
Are you referring to something other than the meeting that you told us about last time, the select board meeting where you stood up
Yeah,
and spoke?
multiple times. I came when we moved here, when I first started my caregiver business in 2010, I came down to the town hall and asked if we could get a home occupation license or any sort of permit, and we were told, no, you have to defer to the state law. But if someone like me comes to the town and is meeting all local and state regulations, and I'm zoned properly for a home occupation, there's nothing anywhere that should have prevented me from receiving that license or an application for that license.
Why didn't you appeal their refusal to give you?
I don't know.
It wasn't that they refused, it was that they told him he didn't need it. So he wasn't gonna, force himself through a licensing process, correct me if I'm wrong, force himself through a licensing process. He asked them, do you want me to get a home occupation permit? I'll do whatever you need me to do. And they would always tell him, no, as long as you're, fill out your application and have your card from the state, you're good to go. And so there was nothing to appeal. It's not like he applied for a home occ permit and it was denied. Then he would have been here appealing it with you all and we wouldn't be here today.
And it's not like he applied for one and got it either.
Correct,
but why
because they
would I
told him
not
he
have?
didn't, they told him he didn't need it. He would have done it. It's not a problem. Like I said, that would have been the opportunity for this.
Right, but
town.
we're not imposing any local sanction on him for not having that license.
Because the town told him he didn't need it.
Right, but, and we're not doing anything as a locality to him based on his not having that.
Can
The
we,
only thing is we can't certify that we approved something that if we didn't approve it, and that's what we have.
can I just take
Yeah.
a second, Jill?
Yeah.
We go over here. Thank you.
I'm not sure where we left off.
Can I ask you another question? The statute says, when it talks about municipal approval, examination approval at the premises for the conduct permitted by this chapter being the Medical Cannabis Act. Okay. If we were to conclude that we think probably at some point a town official did examine the premises and approve in some way its use for cultivation of medical cannabis, which is conduct permitted under the chapter, would that constitute the kind of municipal approval that the statute is talking about? Or must we have approved its use for IHS extraction?
Can I answer this?
Sure. While I ponder.
I'm
add clean it.
assuming this is in reference to the letter.
Any of the evidence in front of us?
Yes.
Yes.
I would say that since this mentions cultivation and also, so all the things in here, inherently dangerous hydrocarbon, that's inherently hazardous substance. The hydrocarbon lab is certified C1D1, class 1, division 1 is explosion proof by an engineer. Extraction equipment, standard operating procedures. The required procedure and equipment in place is specified following manufacturing of medical cannabis products. And that obviously refers to the above qualification, pre-qualification of that, and then sale of medical cannabis, which is conduct of any caregiver. So it would stand to reason that any previous document might say the same thing.
So what I would say about it, when this inspection occurred, did they inspect your IHS equipment? Did he see it?
Well, it
The
wasn't
code officer.
set up in the same fashion that it is.
But was it present?
Yes,
That's the answer.
Was it operating?
yes.
So it's everything that code officer saw during that.
It's basically, we
That would be my
upgraded
answer to your question.
our equipment to be more safe. But again, we've been operating and we've had town officials there and let's see what we're doing.
So I appreciate that, but I think I have a more specific question, which is if we were to have doubt that the town had ever approved IHS extraction, but we thought that the town had approved medical marijuana, medical cannabis cultivation, would that be enough to constitute, to certify that this person was operating with municipal approval based on approval of cannabis cultivation, but not IHS extraction?
If you use the definition of usable marijuana that was in existence when he started,
And allowable caregiver conduct.
because that would include any mixture or preparation. And so arguably, any mixture or preparation would include extraction. And then you couple that with the fact that you had an inspection, the substance of which, included all of that equipment. So yes, if you use the definition of usable marijuana from when he first started operating here, before they sort of added this other, next level regulation for IHS, then yes, he would have been approved for all authorized caregiver activities, which would have included extraction.
Yeah, I think we're missing each other because I'm asking a different question, which is, if we didn't think he'd been approved for extraction, but we thought that he had been approved for cultivation, is that enough to qualify under 2453D or? And I'm not trying to trick him, just trying to find the language so I can, 2429D. Which says Manufacturing facilities that are operating with municipal approval in the municipality prior to the effective date of this section. I'm sorry. Yeah. Would that be municipal approval under the definition of municipal approval, which is examination and approval of the premises or conduct authorized under this chapter, under the Medical Cannabis Act? So if they approved him for any purpose under the Medical Cannabis Act, is that good enough? Or does the town have to have approved him for IHS extraction
That
to
through
come under
the
2429D?
Consent agreement, that could be accommodated, right?
Yes, so to answer your specific question, based on the specific facts and circumstances of what has gone on here, my answer is yes. My answer might be different in another town that had a different process, that had a marijuana licensing program or had other safeguards in place. But for what I know about the process that has gone on here, the fact that an examination took place of his premises related to caregiver cultivation, or at the time that that took place, because unfortunately we have to rewind the tape to 2018. I do think it includes everything that was going on with him at the time. And so that would include extraction. But that's my opinion. If you're looking for a pathway there, that's the pathway, is that the town was aware of all of his authorized caregiver activities, and that included extraction because the town was.
I mean, I don't think we would draw any legal conclusion about what the facts mean.
Yep.
You'd have to argue that in the state. The only question is, if we factually find A but not B, does that help you?
It's really whether or not you're going to sign the local authorization form, whether or not the code officer or another authorized individual from the town is going to sign the form. Because they've gone off that letter right there for the last 2 years and accepted that as local authorization.
My understanding, they
grandfathered.
won't accept this letter anymore.
Well, it's.
We're grandfathered as far as the state is.
The reason they
concerned.
don't accept it is not because they doubt its validity, it's because they have a new process in place. And so now they have a new form. Every time they have a new form, we redo things. And now we have
They're
this new
asking for
form.
some very specific.
They do.
certifications
Right.
that They didn't ask
Which isn't
for,
actually
and that
really
don't
appropriate in my.
don't necessarily appear in this letter.
Correct.
Okay.
It's definitely it's not a Cinderella moment, right? The shoe doesn't fit perfectly here.
Right.
But I think there's enough where the town should be concerned. That's not a threat about litigation. Let me be clear. Sometimes when I say stuff like that as a lawyer, I think people automatically assume what I mean by that. The town should just be concerned about how they've regulated this issue over the years for one of their residents, who's lived here a long time, raised a family here, has been fully transparent with the town. And the only thing that's changed this year is this form. And all that's required is that the town acknowledge that he's a grandfathered caregiver. And then, he gets to move forward and you fill out the form and like I said, he's back in a year with another form.
Okay. I've been doing a lot of talking.
On a slightly different note, I know hazardous materials quite well. I've worked with them extensively. I'm just kind of curious, Jordan. The letter from Alan said that the state certified and not OSHA. How much butane do you keep on hand at any one time?
A couple 100 pounds.
Okay,
And if I may.
And it's in a
add-
class 1, division 1 space, so it's got sensors and constant ventilation, alarms. It's safer than
Hang on.
any
What's
barbecue
required in
grill.
the state of Maine is not OSHA because, they regulate employee safety. What's required is that his equipment be certified by an engineer licensed in the state of Maine. And he has to provide that certification to the state now.
right, but there's a state agency that says the engineer is capable, does meet the credentials, qualification.
Yep.
But he
And
doesn't
those-
interact with OSHA is my point. He just interacts with a licensed engineer.
That may be, but I wonder, does the fire chief here in Pownell know you have a couple 100 pounds of butane on hand?
Does he know anyone has 500 or 1,000 pounds of propane?
Propane's much different, buddy.
Propane's actually more volatile and more flammable.
No, butane has a lower flash point and a much higher specific concentration density than propane.
Okay,
It's handled much differently, buddy. That's why it has to be placarded, identified,
right.
all of those things.
I can explain to you the difference between the two if you like, but it doesn't sound like that's,
Well, what's the answer to the question? Does the fire marshal know or?
no, I've never been I've never been asked to present it to them by anyone or, I mean, my last
Certainly
contact
the
before
code
now was
enforcement
with
officer knew.
Alan.
Yeah.
And I asked him if I should speak with the fire marshal or anything, and he said since it was certified by an engineer, like we have fire suppression, we have everything, so. We're follow all NFPA regulations. It's an extremely rigorous process to get one of these spaces certified by an engineer. It costs thousands and thousands of dollars just to have them come in and tell you if the space is safe, not to mention the hundreds of thousands of dollars of equipment to make it safe. It's an extremely rigorous, very difficult and expensive process. But I'd be happy to have it inspected by a fire marshal or sure, I did provide her with early on with the engineer certification. I mean, everything, you know, every piece of equipment, every nut and bolt in there is certified.
I don't doubt it, Jordan. I've got to tell you, I have a great deal of concern that the little local fire department might be called to your place, not realizing that you have a couple 100 pounds of butane. Typically, my experience with the process, if OSHA concedes that the state investigator can act in a full capacity, knows the rules and regulations, that state investigator is still required to notify OSHA that they have certified your facility. That OSHA acknowledgement includes sending word out to the local fire department that you have this very flammable substance on hand.
I guess that would be on OCP to do that, because they would be the ones who inspect the lab as a state regulatory body. And then it would be another body that would license the engineers who would do the third party.
Well, I mean, and you
Review
know,
of
this
the
isn't
space.
new. That doesn't alleviate your concern. He's had that there for a decade. But he's an open book. If the fire marshal wants to come over and you all want to put a stipulation about that somewhere on an agreement, he'll happily do it. I mean, his family lives there, so he's not putting
I
his family
understand.
at risk.
I understand. Nobody
Yeah.
plays with fire intentionally.
I mean,
That's
I
right.
can tell you.
But no, I mean, you raise valid points, but you know, now that OCP has this process in place, it does involve, his responsibility is to have it certified by an engineer in the state of Maine. What happens with that information afterwards, we don't know, but that's been part of the fits and starts of the Office of Cannabis Policy as they start to develop these relationships with different state agencies.
And we do have OSHA regulations that are built into our standard operating procedures.
Yeah, and the
in case
safety
of
plan,
occurrence.
for
In my
sure.
safety.
And,
plan.
and the safety equipment.
And everything is built like the lighted exit signs, all the markers saying, you know, if there's hazardous or flammable materials, all the MSDS sheets, eye wash stations, like you name it, we've got it.
I appreciate all that, Jordan, but
Yeah.
I would hope you could appreciate the town's standpoint too, that you're doing all this in a residential area that involves some measure of industrial regulation, and the town's not aware of it.
Yes, they are.
The town's been aware.
They've been aware of it for a very long time. Whether they want to admit that or not may be another story, but I've been here since 2010. I've talked to basically every code enforcement over that period of time about my operation. I've been nothing but transparent and, I've been assured, I've been promised by the town that we would be grandfathered in writing and in person on multiple occasions, and I'm feeling quite let down at this point, standing here now.
Anyone else have any, Bill, any other questions for? Do you have anything else for us?
Well, what do you feel as though you would be comfortable talking more about what this consent agreement looks like and
We're gonna
think that's a
consult
step
amongst
ahead.
ourselves, Jordan, and with our attorney and, we've got some more deliberating to do.
Yep. I'll just tell you, I know Jill has done this in multiple towns. She
Yep.
just did it in Yarmouth. Or I don't know
Not
if you did
No, that
Sean's.
wasn't me.
Anyway, this form is causing problems everywhere. She's done it for multiple towns. You
What
know,
he's-
following
yeah,
that,
What he's referring to is just hoping we find a pathway forward. We understand the parameters here of the ZBA. But this is our fourth or fifth time here, and that's not a complaint. We're really happy that everyone's taken such an interest in his business and given us this platform. But we're hoping that the outcome will be, you know, no matter what happens here tonight, that we move in a direction to reach some sort of agreement with the town.
Yep.
And that's why when you raise valid issues, I say, well, if we get there, let's put it in a consent agreement that the fire marshal's gonna come out every 6 months, or that, you know, he's got Jordan's cell phone number, like, he's willing to do whatever. But a lot of towns have licensing programs that take care of some of these things, and I know this town isn't there yet, and may never be there. But, you know, when you've got a grandfathered caregiver willing to be regulated, might as well take him up on it. Thank you so much.
thanks.
Jim?
All right, let's start maybe with the last comment, if I may. For the record, Jim Katsifikis, Perkins Thompson here, representing the board. And just to be clear for everyone in the room, I'm here as outside counsel to the board. The board is an impartial body hearing the appeal. I'm a neutral attorney. I'm not representing the town, I'm representing the board. Barb may have some different rules on that one, but I do represent the board. I'm here as your attorney tonight. So I'm speaking in that capacity and trying to help the board reach its resolution. The town does have an ability to enter into a consent agreement to resolve a violation of the zoning ordinance, but that's something that's the select board would authorize. And that's to resolve a violation. There's no violation of the town zoning ordinance that's been alleged here. And that goes to the issue of jurisdiction that was raised earlier. This is not the code enforcement officer's decision in the administration and enforcement of the zoning ordinance. This is the code enforcement officer's decision with regard to a form that the town has been asked to sign. The statute does not say who on the town staff is supposed to sign that form. It just says the town. There is no provision for appeal from that form for a decision not to issue that, to sign that form. There's nothing. So on the other hand, to the extent that you're being asked to determine that this use was grandfathered, that is similar to the sorts of decisions that a code enforcement officer makes under the ordinance. And so that's why at the last meeting it was decided, well, you know, all things being equal, we'll say the board has jurisdiction to hear this appeal because that's what the CEO does. Is this use allowed? Is it permitted? Is it prohibited? Is it grandfathered? And that's essentially what's being asked here. What complicates things here a little bit is a caregiver license is issued by the state. The municipality has the discretion to regulate caregivers reasonably. The municipality cannot prohibit caregivers under the marijuana law. Can regulate them reasonably, cannot prohibit. And having the card initially as a caregiver back in 2009 was actually confidential under state law. So you wouldn't have any reason to know that anyone in this town was a marijuana caregiver under the state law unless that person disclosed it to you. It's not in your land use ordinance. The town never adopted an ordinance to reasonably regulate caregivers or to regulate any marijuana operation. The town has no current ordinance doing that. So you will not find marijuana caregiver in the zoning ordinance. It's just not a use that's mentioned. Whether somebody came in to get that approved as a home occupation or whatever, you've heard testimony on that. The issue really is the form. A local authorization form, as now required by state law, was offered to the town. The code enforcement officer was asked to sign it and declined because there are really two questions. The first question is, does your town have a current marijuana ordinance, cannabis ordinance, and is this approved under it? And the town does not have such an ordinance. So then the question is it grandfathered in the sense of, was it operating before December 13th of 2018? There's a letter dated 3.5 years after that says that he was grandfathered for marijuana cannabis cultivation and that he had equipment for extraction on the site, but it doesn't say that he was grandfathered for that. And when the former CEO was talking about grandfathering in 2022, was he talking about grandfathering under the cannabis law? Was he talking about grandfathered somehow under local ordinances? We don't know. He just said for cannabis cultivation, he was grandfathered. And that he has this other lab equipment that he inspected that would also be included for these other, but it didn't say he was grandfathered for those, just for cultivation of cannabis. And state law is a little squirrely because, as Member Ruprecht mentioned, the question is, was he grandfathered or not? Was he grandfathered with municipal approval? And if you look at the current statute, that section 2429D, the language is a little different. Because under 2429D, 2, it says that a municipality may not prohibit caregiver retail stores, registered dispensaries, cannabis testing facilities, and manufacturing facilities that are operating with municipal approval in the municipality prior to the effective date, December 13 of 2018. So the town can't prohibit someone with these cannabis manufacturing facilities operating with municipal approval as of that date. That's in D2. In D3, it says that a municipality may not authorize cannabis manufacturing facilities that are not operating on the effective date of this section to operate in the municipality unless the legislative body has voted to adopt an ordinance. Well, it hasn't voted to adopt an ordinance, but this doesn't say unless they were operating with municipal approval. So D2 says that you can't prohibit them unless if they have municipal approval and they were grandfathered. The other provision says that you may not authorize these facilities unless they're grandfathered, but doesn't require municipal approval. And yet the form that was offered requires municipal approval as well as grandfathering. So it's messy. And it's even unclear whether this is something that should be before the Board of Appeals. This is really a state law question and a state form. So if you are going to say that this was timely and you have jurisdiction because these are the sorts of questions that a CEO is asked to answer, fine, then the question is on grandfathering. And I think given that the form is based upon the statute and statute in D2 does say that you can't prohibit it unless it's both grandfathered and has municipal approval, probably safer to say that you need the municipal approval. And then the statute goes on and defines municipal approval and likens it to being something like a conditional use approval or site plan approval, but specifically says not a building or electrical permit. And the evidence that was provided here is that the only permits in the file for this property are 2 electrical permits, which would not cut it as showing municipal approval under the statute. So I don't know where that leads you. I don't know if that helps, but I have taken a look at that and the materials that were supplied by Attorney Ketchum. And while they support that maybe it could be grandfathered, maybe, depending on your interpretation of state law under the cannabis law, the Medical Marijuana Act of 2009, that doesn't get you over the hurdle of municipal approval, which is required under D2 and doesn't show up in D3, but shows up on the local authorization form.
Can you give me your thoughts on the question I was asking Attorney Cohen, which is if we were to conclude that at some point a town official had given some kind of approval, examined the premises, approved of the obvious use of it as for marijuana cultivation, would that constitute municipal approval under 2429D2? Based on that ambiguity in conduct permitted under the chapter.
Right, and that would require the appellant and the Office of Cannabis Policy to read into that, that cannabis cultivation, going back to 2010, would include extraction.
Why? What if it doesn't require approval of extraction at all?
Okay,
What if cultivation is conduct permitted under the medical cannabis
Right.
statute? If that conduct was approved, why wouldn't that constitute the required municipal approval for purposes of 2429D?
because the specific approval is for extraction, not for cannabis cultivation.
Is that because because the only activity that we really can be talking about as it applies here is a manufacturing facility?
That's what the local authorization is for. Well, it's being requested in this context for the manufacturing facility.
And a manufacturing facility is not just cultivation, it's actually some kind of further processing.
Right, you might be able to read it into that mixture or tincture language that was in the
Well, manufacturing
men-
facility is a specifically defined
I
term in the
understand.
statute we're looking at, so I think we'd look at that.
Well, we'll look at that for now, but I'm saying if you were trying to make a case that we're grandfathered because it could have been done lawfully under the prior, that, who knows? That's beyond what we can talk about.
Other than construing the term, what the factual
Mm.
premises are that the term municipal approval as used in this form means, is there any, I mean, does the CBA have any role to construe the Maine Medical Cannabis Act or to construe what is and what isn't grandfathered? I mean, we're being asked a factual question. Did the town issue municipal approval? And we can look at the statute and say, what does municipal approval mean? And factually answer that question, but
Well, someone
anything else for us to do?
a good question, but the town is asked to sign off on that local authorization form. And in order to get there, you have to be, somebody for the town has to be able to certify and, or state for this form that this is grandfathered with local approval as defined by state law. And here, the code officer was asked to make a decision, it did, it's now before the board. It's adjacent to the type of zoning question, is a use grandfathered, that you typically goes to the code officer. So if you assume that, then the board could assert jurisdiction here. And it's a question of determining whether the facts fit under this statute and under this requirement of that form.
If I may, oh, go ahead, Clint.
One last question. We talked about this last time, but I don't know that any of us had clarity. Is the 30-day requirement for filing of an appeal, is that jurisdictional or is that something that is waivable here?
There is no good cause exception to the 30-day rule under your ordinance. And so it is jurisdictional. I break it out as different, just as talk about jurisdiction going to subject matter and then timeliness just as to that time frame. But they are both jurisdictional. If an appeal wasn't filed in a timely manner, you don't have authority to hear it.
That's my question is, do we have the authority to overlook that?
Well, you could overlook it, or you could, as the appellant has asked, talk about the 30 days beginning to run at a different time. And that was when the select board said, we can't help you, go see the ZBA, which is what the appellants have argued. And that's an argument that this board might accept. The ordinance does say from the decision appealed from. The decision was in March, not in April or May, but there was an issue as to whether that was an actual decision, at least in the appellant's mind. And so they are timing this from the date when they were told by the board, the select board, to come here.
I mean, a little.
You
weird
could
for us
boot-
to say
You could
it has
bootstrap
to
that.
come from when the CEO made the decision, but we're not even sure the CEO can make the decision.
I told, yeah, so then maybe that's another reason why you would give some leniency here and measure from the select board. To try to help the board along, because not only do you have to make a decision on this appeal, but you also have to issue a written notice of decision with findings of fact and conclusions of law within 7 days. Tall order, I did prepare a draft decision setting out findings of fact and conclusions of law. The last is grant or deny with a slash and you pick one. But some of the findings are toward this may be grandfathered, but no municipal approval. No municipal approval existed here. It is just a draft, and I would offer that as something to work from because I think you can at least reach agreement on the findings of fact and then maybe make some changes on the conclusions of law piece. But it might help this board get going on that and reaching a decision. If that's okay with you, I have copies for everyone to take a look at. How does the board feel about that? Or would you rather make a decision first, tell me to write it and come back in a week?
I'd like for us to deliberate a little bit about, discuss it.
Okay.
Yeah.
You tell me, I have it here if you'd like, and if you want me to hold off, that's fine too.
Why don't you at least at a minimum provide it to Attorney Cohen now in case, so she has a little bit of time to look at it, in case she has.
Take a break and all look at it?
Um,
That help?
Jim, can I ask you one
Certainly.
more question?
Yes.
Correct me if I'm not supposed to, but let's say that we do accept this letter as constituting a grandfather, but we don't have municipal approval. Does Jordan have a way forward by entering into a consent agreement with the selectmen?
There's no zoning violation to try to resolve by a consent agreement.
Isn't there a potential appeal to the Superior Court?
You-
from Our action that could be resolved
Right, that would
consent
That
agreement?
would be more of a settlement rather than a consent agreement. No,
Selectmen do?
they could, if they were so disposed, to try to head off everyone going to court.
It's not something we have the power to do.
It's nothing you have the power to do. Okay, so I'll hand this out to everyone. I don't know if you want to take a break and read it or whether what you would prefer to
I don't
do.
mind looking at it.
Okay, Chair, is that?
Please,
Okay.
yes, yes, absolutely.
Illegal with more of that.
I do think in fairness, we shouldn't close the comment period until Attorney Cohen's had a chance to look at it.
I agree. Thank you, Cliff.
Share any thoughts she has about it.
Few more minutes?
Anybody have copies of the affidavits that the applicant submitted?
I may have. Cliff. And he's. You pass it over.
Are those the client testimonials?
That's not it?
I have that.
Okay. I'm afraid that's all I have. They were. Dick, would you pass that? Thank you. Sorry.
And do you have copies of affidavits from the applicants?
There was an affidavit that was, I think, brought to the meeting, the last meeting by the applicants, and I remember seeing it. I don't see it in my file. Was a copy left as part of the record?
Oh, I don't have one.
Ah. You don't have one?
It was in a manila envelope. There was only the one copy of each of the affidavits. I gave it to the chair on the June 3rd meeting so that the members could view. I think the members did view it that night. Yep.
I don't know where it is. Well, with Ketchum, I don't remember that. No.
I think it is an administrative.
Is it or administrative or miscellaneous? Oh, it is.
Would you like me to?
Ms. Cohen, do you have any?
I submitted them.
Yep, right. No, I was just, to get things rolling again. Do you have anything you want to say in response to, the draft? That our attorney gave to us for review?
As I read it, honestly, I felt like it made a great case for you to rule in our favor. To be quite honest, when I saw it laid out in black and white, I thought this reads well for my client, other than the, like I said, on the last page. Regarding that he does not have municipal approval. I mean, that's been our argument all along, is we do think he's been operating with municipal approval. But other than that, as far as procedural history and everything that's stated in it, like I said, up until I got to that paragraph, I thought they really should rule in our favor. Because it does lay it out pretty clearly. And really the only dispute is this issue of municipal approval, which I think, if there's any doubt, should bend in my client's favor. Apparently he signed an affidavit. His recollection of the events has not changed. And this is what, our 5th time here. He says the same thing every time. He's credible. He's a town resident, longtime town resident, you know, raising his family here. So he's worthy of belief. And like I said before, the things that Jordan says are evidence to be considered when you're evaluating whether or not he was operating with municipal approval. The town definitely knew he was here. Because they had been out there and he had repeatedly been here asking for documentation and asking to apply for a home occupation license. So we would ask that you rule in his favor. Yeah.
And if I may, I'm not telling the board how to decide it. This was simply a device to try to give someone something to start from. And I think you can get through the top of page 5 either way. It's, we can make any amendments that you wish. This is your decision to make as a board.
Any discussion, folks? Anyone have any observations, conclusions?
For me, the conclusion that I see is, if I have it right, there was really nothing for her to look at. Oh, sorry.
Nothing for Ginny.
Nothing had been done wrong is what I'm thinking. And so she said there was nothing there.
Jordan, the affidavits. Would you just describe the content of the affidavits?
In 2017, Scott Howard was trying to pass a AU ordinance in Pownell. I got involved with that. Adult use. So some of you may remember this. I was on the board at the time. So I went to 2 whole meetings and then I got to the 3rd meeting, which was tabled. In the first 2 meetings I was there, I asked specifically about my lab. So in the affidavit, it basically says, I was told in 2 separate select board hearings in 2017 by the select board that I would be grandfathered, whether there was an ordinance, a moratorium, or lack thereof of either of those things. And my wife was almost also there and witnessed that. And she also submitted an affidavit stating that.
When you say your lab, tell me as specifically as you can what you mean. What did you tell the select board about your operation?
Just my extraction lab. I didn't say, like, it wasn't really a time, and I guess I'll reference, like, through these 5 hearings, I haven't explained what any of my equipment is. Right?
So you didn't tell the select board that you were using hazardous substances?
Hmm?
You didn't tell the select board you were using hazardous substances?
No, I did.
Okay, I'm asking you, tell me as precisely as you can, what it is that you told the select board.
I said, what about my business and specifically my laboratory. And laboratory meaning my hazardous, it wasn't called inherently hazardous extraction at the time, but the town knew what I was doing at the time, so it was implied what that meant because of the previous knowledge that the town had of my.
So the way the select board knew that you were using hazardous substances was because you used the word laboratory.
Correct.
Did you use the word extraction?
I believe so.
Okay, there's no wrong answer. I was just asking.
An extraction can be done with or without hazardous substances.
Correct.
Yep, but again, I had previous conversations with town officials stating that we do use.
But in terms of what the select board knew at that meeting, they knew you had a laboratory and that you were doing extraction.
Yep, yes.
Okay.
But not excluding.
But they didn't know anything more specific about it.
Oh, they did because of previous knowledge of my business in the town and me coming to the town and telling them what I'm doing.
So when did you tell the select board that you were engaged in hazardous substance extraction?
I had told previous code enforcement officers since the onset of my time as a caregiver to be transparent with the town. I don't feel like it's not really my fault that no record has been kept of that.
Just trying to figure out
Yeah.
what they knew and what you told them
Right.
and
Yeah, I mean, they knew what I was doing and they knew exactly what I meant when I said it. I don't know how else to put it.
okay.
I'll respond to one thing
Yeah.
that, by both Attorney Katsifikas and, I'm sorry, this board member. The code enforcement officer, when she sent the email to Jordan that said, we don't have a current ordinance, we don't have a future ordinance. Part of the error was she never even considered grandfathering. So it wasn't part of even her decision. And that didn't come across in Attorney Katsifikas's remarks about that email, and it's not in here. So there was never, so she's either to look for an ordinance or to look for grandfathering. She never went through that exercise.
You want
To
us to
determine
send her back
grandfathering.
to do it over
I
and
don't,
make a conclusion on that and come back? I mean,
my point was.
we are considering the question now of
Yeah,
whether
no.
she could check that box or not.
Right, no, I was just saying, like, when we talk about the error, the way her job was described included looking at an ordinance or looking at the grandfathering. And so she didn't look at both of those things. She really just relied on the town not having an ordinance.
Well, and I think that has more, like, there's a lot, you did the right thing reaching out to the town attorney for advice on that. And I think that some of the information you may have got was incorrect. Some of it was correct. So, go ahead.
When you read the form, it talks about grandfathering. It asks for the ordinances of that fact. So I did not feel that I could sign that because, I'm sorry, I'm losing my voice.
Oh, I'm sorry.
It's okay. I just
I
want
heard
to
you
know.
coughing.
I know, I'm talking today. I couldn't yesterday. So when I read that, basically that's what I saw.
Yep.
And it wasn't, I couldn't prove that it had been grandfathered because there was no verification. When I read Alan's letter and my definition of cultivation did not include the extraction equipment under
Right.
that place. And the whole simple piece, I probably should have expounded, the fact that with the ordinance and just not giving you that simple no decision of no ordinance, da, 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 da. But I really saw that as that was the crux of the form. And we don't have a town grandfathering clause. It was eliminated in 2017. And I realized that the state grandfathering could happen, but I had nothing that could tell me that. And I
Right.
couldn't sit there and get that from Alan's letter.
Well, the state has accepted it as proof that we're grandfathered.
But I
and
didn't even have a letter from the state.
I know
saying
they're
that
not
they
good at
accepted it.
doing that. But like my registration for my lab
Mhm.
and my license for my lab and the form that I've given in the past that says that that's authorized conduct for us as caregivers is all proof that that form has been accepted by the state and that they've accepted that we're grandfathered under state law. just by way of them issuing that license and allowing that conduct, they wouldn't do that without that letter. Therefore, they're reading that to say that that includes what we now call inherently hazardous extraction.
But I
And I'll
don't know.
tell you,
won't- they
the
won't accept
letter
that
is
letter.
clunky, and I was
They've-
actually
they've
working
finally
with
got to it.
Alan to try to like clean that up, and the state took the letter I had, and I got a million things in my life, so you know, it seemed fine, and now, they're changing this form, and, it says right on there that it's a town official saying that we've been in operation since 2011, and I don't think anything could speak more to the fact that we're grandfathered than the town officials stating that length of operation and the conduct therein, whether that letter is constructed in a proper fashion. I take issue exactly how that's laid out too, but I also take issue with it not being kept on file here
Did,
and not having not having record of any of this stuff that's happened over the years with me. A lot of that's not, it's the town's responsibility, and I'm the one left holding the short end of the stick here. And I'm kind of like really expecting you guys to make this right for me. And one thing I want to mention, a consent agreement has a lot of breadth, and it can encompass almost anything. So a lot of the things we're discussing are, I wouldn't say inconsequential, but they're not as important or set in stone as they are on that form if we operate within a consent agreement. And I really think, given the circumstance and given the confusion around this form, and I'll tell you, these forms are causing the same problem all over the state. My friend lost his store, had to get a whole new ordinance made, and it's happening everywhere because these forms are really
Definitely a
confusing.
learning
I
curve.
have-
for 'em.
So I think we can reach an
Well,
agreement, some sort of agreement.
We want to prevail here.
Ah.
If we don't, then we'll take the next steps and meet with the.
I have a
select board and
question.
See if we can hammer something.
Can let-
Did Alan write that letter on his own or did you assist him?
He wrote it.
It's on
He
your
wrote it.
agenda.
Yeah,
Okay. All right. Thank you.
I mean, he came over and I explained
Okay.
what,
Believe me,
what the
we've
different
wrote
things
it,
were.
it would read
If
a
I
lot
wrote it, it
differently.
would look a lot better than that.
Thank you.
Attorney Cohen, who we heard from Mr. Katsifiakis that we don't have the power to enter into a
Yeah,
consent
that's what
agreement.
I
Do you have any reason to
remember.
disagree with that?
No, I don't. I explained that to him on the way in, I mean, I think there's a pathway to prevail right here tonight.
Okay.
If not, we will go once more
Back to
to
the
the
select
select
board.
board with our hat in our hand, hoping that we can resolve it.
Can I ask a second question, which is, assume that your route is going to be some kind of negotiation with the select board. Does it help you or hurt you if prior to that, there's a decision from this board saying that factually he did not have municipal approval?
Well,
Um,
one would assume that wouldn't help us.
Yeah, I hear what you're saying. I don't know what to say about that. I mean, we have a select board member with us tonight, so there's no
Two.
secrets here too. So it's all very
I
tricky.
don't mean hurt you with the select board. I mean hurt you with the
With the
state.
state?
Where
Only
ultimately,
in the short term,
isn't the end game that you have to go to the state with something from the town
that form
that's gonna meet?
Right.
signed by one of you.
And it's been
Yeah.
that letter for years, and now it's just this, and
I mean,
it's
that really
acknowledging the
is-
same thing that's already been acknowledged. by
That really is the
town.
only thing that's changed and because I've been doing this so long and Jordan's been doing this so long, it's just interesting to sort of have a client so in the hot seat after it took the state 6 years to fulfill their mandate. And I know that's not on any of you, But it's a tough pill to swallow for operators who've built businesses literally in their front yard, less than a mile from here. And, you know, for him to now be in this position when nothing's changed at the state level other than them generating finally a license application and a new form. And like Jordan said, I mean, we're having these issues in every town. It's fine. But if we had had this form 6 years ago, probably a lot of towns' ordinances would look different today. And even the laws written at the state level, like the attorney said, we always have these problems where things don't exactly line up. So the statutory language doesn't even line up with the form.
We're recodifying the entire medical law right now.
Yeah, that eventually will happen as well. I mean, we've been operating with an outdated set of
Directly and
rules
indirectly.
since 2018. Because we can't get a set of rules through the legislature for a variety of reasons. So these situations, like I've told Jordan since day one, it's not perfect. And I've never come before this body or the select board and said it was perfect. But we do think he's grandfathered. I mean, he's, you know, open, as we sometimes say in property law, he's been open and notorious about his business here. Like it's literally in a tiny house in his front yard, right down the road. You drive by it every day. So, you know, I hope we don't get there, but what would a court do with this notion about municipal approval? I have no idea, because you're just as capable as any other tribunal we would end up in front of, and you're struggling with it. And, you know, that's why we think potentially we end up back with the select board and asking them to work with us to work something out. But as far as, does it hurt him at the state level to get this denial here in the short term? What hurts him is not having the form. Your denial here is not necessarily going to the Office of Cannabis Policy. I mean, we have no reason to hide it from them, but they're looking for the form. So that's what hurts him in the short term, and his caregiver card expires in 10 days.
Well, I'll still be able to do everything except for
Everything but,
IHS extraction,
So yeah, it does hurt him, but
which
not
is
as
2/3
directly.
of our income.
Yeah.
So it's gonna hit us in there, and we're already in a really, I'm spending every dime I have to have her here and to have my other attorney at all these meetings, and
So,
it's a lot. No, I'm not saying you're awful, you're great.
kidding.
That's why I pay you to be here.
Thanks. No, and I mean, we do appreciate the amount of time the town has spent.
Yeah, you guys have put in a lot of work and we appreciate
Yeah.
that.
Thank you.
Thank you.
Anything else?
No, thank you, Jordan. Jim, any final words? All right, going to close this to just deliberations by the board from this point. Anybody want to start us off? My feeling, given the narrow band, or given what we have to work with, that I could recognize the letter from the code enforcement officer as grandfathering, but I don't see where municipal approval has been awarded, recognized, given in any form. Based on that, I would have to vote no. Anyone else?
Yeah, I mean, the statute is not very sensibly drafted. And so it puts us in a terrible position of having to do something that seems almost irrational, but follows the law.
Right.
Because I don't know that we have a lot of choice. It's municipal approval is clearly defined in the statute. It means that there was an examination and an approval of the facility for the use that is in question here. And I think that has to mean IHS extraction. whether there was an examination of his premises and an approval prior to 2018 for cultivation of marijuana, one might conclude that from Alan's letter. I don't doubt the genuineness of the applicant's belief that whatever conversation he had with Ryan Keith was some kind of a approval of his of extraction activity, but the fact is, we have no written evidence of it, and I can't really conclude that the town or even Ryan shared that belief. It's just, there would just be more of a written record. If so, there's too many hurdles to approving that kind of a use for it just to have been done without some kind of writing. And I find it odd that when the applicant's whole purpose of asking Ryan Keith to come and inspect was because he wanted to have something to allow him to comply with the statute, that there is no writing that reflects it. It's just, so I think it just seems there must have been some kind of a miscommunication there, or a misunderstanding on the applicant's part, which is unfortunate, but is not municipal approval. You know, it's not a permitted use in his zone. Town's always had a hazardous materials ordinance. These are reasons I would expect to see something in writing if some municipal approval for that kind of activity had been granted. Not having anything in writing is just really causes me to doubt that there was actual municipal approval. And as far as what was said at the select meeting, again, I'm not questioning the genuineness of the applicant's belief that the select board must have understood that when he used the word laboratory, it meant that he was using hazardous substances to engage in extraction, but that's not a natural conclusion for a person to reach from the use of the word laboratory. And I don't see any evidence that that's what the select board even was aware of, much less than I'm not sure it would constitute municipal approval if they were. So I don't think we can conclude from the letter or any of the testimony that we've heard that there was actual municipal approval of IHS extraction, and it would have been more fortunate if the state had said, if the town was aware that you were engaged in medical cannabis activity, then prior to the grandfathering date, then you're fine, but that's not what they said. And that's not what they're asking us to certify. And I don't see an error in Ginny's not filling out that form, because she can't check off that box about municipal approval. And I don't think there's any dispute that the warrant and ordinance boxes have to be checked off. No, I don't think even the applicant is saying any different. So, it's very unfortunate.
Yes, it is. Yes, it is. My kid sister is a psychiatric nurse practitioner. She's licensed by the state to prescribe medical marijuana, even though she's a teetotaler herself. But she told me not all that long ago of the wonderful response that people are receiving schizophrenia, a number of conditions from the use of marijuana. Jordan, for what it's worth, I know you're doing a good thing. Dick, Bill?
I just, after going through this many times, there's just so much that's missing here that I hate to make a decision that way. I think that a consent agreement might be the best way if that could be worked out. Definitely don't think that Ginny did anything wrong or missed anything. I think she's right spot on. And I think, I don't think we can vote for the consent agreement anyhow. So right now, I would have to say no.
Bill, you're all set, you said? Okay.
Yeah, I just echo what Dick says. I think a consent agreement by the town that resolves this matter, if that can be worked out, I think would be in everyone's interest, including the client and patient population that he serves.
Anything else? Well, if so, I move that the board vote to deny the request for an administrative appeal in response to the Pownell Code Enforcement Officer's decision not to sign the local authorization form required by the Office of Cannabis Policy. Reason for which is municipal awareness approval was not given.
And can we add to that motion that we vote to authorize the chair to sign findings of fact and conclusions of law to be drafted by Mr. Katsiakis, consistent with the findings of the board,
Agreed.
which will be an amendment, I think, of that draft, but probably a light one then.
All set? All those in favor, please say aye.
Aye.
Aye. All those opposed? The ayes carry. The request for administrative appeal is denied. That being the case, I will accept a motion to adjourn this meeting.
Second.
All those in favor, please say aye. Opposed? This meeting is adjourned. Clean up that